Hi, Pam. This is Felicia. Can you hear me okay? Pam?
Yes, I can hear you.
Okay, good. Should I make it louder?
Sure.
Okay. Okay, how's that?
Yes, I can hear you just fine. Let's Tannis, can you hear the hearing officer? Everybody else? Okay, Mr. Maxwell's got a thumbs up. Everybody does. I see Mr. Davis as well.
Great. One more question. Did you send the invitation to this conference to the Center for Biological Diversity
Yes.
folks? You did. Okay. All right.
I can send it again if they don't sign on. They just sent a reply to a motion to disqualify.
Oh,
So-
okay. I did not see that. So maybe they're
just
planning.
Just popped in. I haven't even opened it.
Okay.
Madai, can I get you to send the link to, I'm going to forward the email, just so we can get started. Let's see if you're on it. You
Okay.
are, okay. The woman, it's Colin Cox. Would you send the link to this meeting to her? Oh, never mind. He's signing on right now. Sorry, I'm babbling.
Yes, I see him online.
Okay, thanks.
Mm-hmm.
All right. And Pam or Madai, you're going to hit the record button.
Just did.
All right. Thank you so much. All righty. Let's get started. My name is Felicia Orth. I'm a hearing officer appointed by the Water Quality Control Commission to serve in the matter of proposed new rule 20.6.8 of the New Mexico Administrative Code. These would be supplemental requirements for water reuse in the ground and surface water protection regulations. The petitioner is the Water Protection Division of the New Mexico Environment Department. It's docketed by the Commission Administrator as WQCC 23-84R for rulemaking. I believe we have a number of things we're going to do today in this pre-hearing conference. But for the moment, let me just note who's on the platform. Let's see, the petitioner's counsel, Mr. Knight, you're here? Oh, there you are. And then we have several other parties. I'll just do this in the order I see it on the certificate of service. I see Mr. Maxwell. I see Ms. Fox on behalf of Amigos Bravos and Sierra Club. I see Mr. Wexler for NMOGA. Is there anyone else here for NMOGA? No? Okay. Let's see. I did see Jolene. Oh, there you are, Jolene. Let's see. I think I saw that Ms. Taylor was on as well for the Select Water Solutions. I saw Ms. Nanasi earlier. Let me see.
It's not.
There you are. Yes. And let's see, Mr. Dodd. Let's see, I don't think I know Mr. Dodd. Who's Mr. Dodd? Oh, there you are. Okay.
As well for New Energy
Great.
Economy.
Hello. And let's see, Tim Davis for Wild Earth Guardians. Okay, that's you, sir. And then do we have, who do we have for the Center for Biological Diversity?
Colin Cox for the Center for Biological Diversity.
Thank you so much. And so having walked through that list of participants, I'll note we also have Pam Jones and Madai Corral, who are staff at the Office of Public Facilitation. Excuse me. They provide administrative support to the commission. I don't think I saw the commission counsel, Ms. Miller. She sometimes joins these pre-hearing conferences. So let me first turn my attention to Mr. Cox. What I saw in the series of documents in under docketed matters included an entry of appearance by you and Ms. Evans, and then 3 more entries of appearance, one by Mr. So, Mr. Atencio, and Mr. Sage. But I wasn't sure, and then I didn't see a witness list, but I saw notices of exhibits. So could you clarify for me, please, whether all of those are entries of appearance, or whether perhaps Mr. So, you hope for him to be a witness? What don't I understand here?
Yeah, I'm sorry for any confusion. So Mr. So, Mr. Sage, and Mr. Atencio, they all wanted to be parties to the proceeding. But so I helped them draft, and I emailed out their entries of appearance. But the center isn't representing them. I'm not representing them. So they wanted to enter as individuals. They did tell me they were planning to attend this today, but they wanted to kind of preserve their rights as make a notice of appearance in the proceeding. So I'm just here on behalf of the center, and I'm not representing Mr. So, Sage, and Tensu.
Okay, so but they entered, if I understand you correctly, they may have some relationship with the center, but they entered an appearance on their own behalf?
Yes.
Okay. And then my other question of you, while I have your attention, is I noted that there were notices of exhibits, but I did not see a notice or a list of witnesses.
Yeah, the center
Did I miss it?
No, the center isn't presenting any witnesses. Those are just some exhibits that we may be using on cross-examination. And I just filed them so the parties would have them ahead of time.
I see. All righty. Thank you for that clarification. So just to wrap that up, Ms. Jones, if you would re-add or add again Mr. So, Mr. Atencio, and Mr. Sage to the certificate of service. They were on your first one, but not your second one.
Will do.
All righty. So let me start with the things I have in hand. I've walked through all the NOIs and the rebuttal NOIs, made a note of who had identified witnesses, both on direct and rebuttal. Let's see here. Another party, Ms. Michaela, Select Water Solutions. I didn't see witnesses proposed there either, right?
That's correct.
Okay.
Madam Hearing Officer, we are just participating in the hearing, and actually my partner Liz Taylor will be doing that in Santa Fe, but just for the purpose of cross-examination and relying on testimony of other witnesses.
Okay, thank you. All right, so for the other parties, I saw either, well, I know Mr. Maxwell is pro se, and have had him in prior proceedings, so I know he knows how this goes. And for all the other parties, I saw witnesses both on direct and rebuttal described in the NOIs. So the other things I have in hand that I think we should talk about today, I think it might be helpful if we talked about the order of testimony that folks will go in. And I think it would be helpful to address three things that came in the last week or so. One is the revised joint motion requesting the taking of administrative notice of the Bernalillo County Board of County Commissioners Administrative Resolution number 2024-55. And then, let's see, New Energy Economy's motion requesting that the Water Quality Control Commission issue orders necessary and relevant to inform the commission of the matters at issue and in the public interest. This is a request for an order requiring Dr. Pei Shu, excuse my pronunciation if that's incorrect, to testify. And then I have a third motion in hand asking that many of NMOGA's exhibits be struck as not relevant. I know that there is another series of motions, responses, and replies. That was Mr. Maxwell's motion to disqualify many of the water quality control commissioners. That is not a motion for me. That's a motion for the commission itself, and they will be advised on that, as the Environmental Improvement Board was in the Clean Cars rulemaking. You'll remember that, Mr. Maxwell. They'll be advised by their own counsel on that topic. That's not something that I do with them. So,
Madam Hearing Examiner,
yes.
this is Marielle Lanassi on behalf of New Energy Economy. And I just wanted to alert you, the New Energy Economy, Wild Earth Guardians, and Center for Biological Diversity just filed a reply to Mr. Maxwell's motion to disqualify. And so, and in that, we asked that the commission make a determination before the hearing begins. And so we wanted to just apprise you that that was just filed and are requesting an expedited decision.
Okay. I trust you copied Ms. Miller, their counsel from the AG's office on that.
Yes, we did.
Okay. Yeah, again, that's the one series of motions, responses, and replies that I don't really have anything to do with. I will say, I'm just offering this in a friendly way. It would be a real challenge for them to make a decision before Monday, since I don't know how they can meet before Monday, but I will leave that to Ms. Miller to discuss with the chair, Mr. Thompson. Okay. Let's see here. So let me start with the one I considered the, so other than the three motions now I've just mentioned, and the fourth one that will be handled by Ms. Miller and the commission and setting out the order in which folks would testify, is there something else we need to talk about? Someone has come onto the platform with Ms. Fox.
Good afternoon, everybody. Good afternoon, Madam Hearing Officer. Mr. Hightower filed what he termed a rebuttal NOI with, I think, maybe just the commission administrator last Friday. And that is, in my view, out of order. I thought we would discuss that today. And the other point with respect to Mr. Hightower is that I had a conversation with him a couple of weeks ago. I'm really sorry that he is not on this call because I found his notice of intent confusing as to who he represents. I think, as you know, the commission rules require that anybody entering an appearance has to state, or testifying has to state, on whose behalf they are testifying. And he variously identifies the Produced Water Consortium and himself as who he is testifying on behalf of. And we had a conversation, and my understanding of that conversation, leave it to him to say what his understanding was, is that he is representing himself, not the consortium. And so what I told him was, well, this is something, let's, work this out at the pre-hearing conference that had already been scheduled. And, I want you to know that I would expect you to file some kind of correction, because at the very top of his NOI in Exhibit 1, it says he's representing the consortium. So for me, that is an issue. There is a big distinction between him representing himself and him representing the consortium. And I think that should be cleared up by Mr. Hightower if he is willing. Otherwise, it is subject to cross-examination.
Madam Hearing Examiner, this is Mary Ellen Nassi on behalf of New Energy Economy, and I just wanted to say that I object to Ms. Fox's divulging a private conversation on the record, since this is on the record, and that, right now, Mr. Hightower's filings are what they are, and that they're subject to cross-examination, and that, frankly, we would object to any further filing because it's after your deadline. So I think that this should be taken up pursuant to the rules, including subject to cross-examination.
Well, so this is, as you heard me go through with Mr. Cox, this is actually exactly the sort of thing we tend to talk about in pre-hearing conferences, where representation is unclear, or an entry of appearance is unclear, particularly where folks are not represented by counsel. Issues like this tend to show up. And Ms. Jones had mentioned to me that in conversations with Mr. Hightower that she had around his trying to file various things, he was noting that he was not a lawyer and was struggling with the following all of the rules. So. Pam, would you please send an email? I was really hoping to speak with Mr. Hightower as well. And
yes, I just asked Madai to send that email to remind him to sign on.
Okay, particularly because I think his comments, one, obviously, his representation, which is what Ms. Fox brought up. And then my question of him was going to be around what appeared to be a proposal that the person, Ms. Nanasi, would like to have ordered to appear. He also seems to want to have maybe available for cross-examination, but not give direct. I was unclear on that as well. But that was going to be my question of him. And now Ms. Fox has a question of him as well. Okay.
Madam Hearing Examiner,
Mr. Wexler.
you just asked if there were any other issues, and when it's appropriate, I just have a number of sort of organizational questions about the hearing. I don't need to cover it now, but let me know when you want me to tick through that list.
All right. Okay, so let's start with, let's see. So Pam and Madai will try to get Mr. Hightower to join us, and we'll we'll plug along regardless. The revised joint motion requesting the taking of administrative notice of the resolution adopted by the Bernalillo County Board of County Commissioners. I read the motion. I read Mr. Maxwell's opposition to that motion. Were there any other pleadings? I did. Okay. Did anyone who did not write this up, Ms. Anasi or Mr. Maxwell, was there any other party who wanted to take a position on it? I consider it fairly straightforward, frankly, and intend to accept it into the record essentially as public comment. And Mr. Maxwell, you actually set out kind of what my response to the motion was, actually, in your numbered paragraphs. The fact that it was adopted by the Bernalillo County Board of County Commissioners is not disputed. That's a fact. It is a public document, certainly carried the indicia of authenticity that I would look for. The fact that we would accept it into the record as public comment for the commission to consider does not mean that the contents of that resolution are somehow endorsed. Certainly not by me. The commission is just going to have to weigh what's said in the resolution for themselves. So Pam, if you would please make sure that the commission has a copy of the resolution as part of the record. Any questions about that? Nope. Okay. Let's move to the second one. This is where I was really hoping to have Mr. Hightower. Seeking an order requiring Dr. And am I pronouncing it correctly? Pei-Shu, Dr. Pei-Shu? Maybe? Okay.
If you want, excuse me, this is Mary Ellen Essie again for the record. We could do some of the other administrative tasks that I think Mr. Wexler and I and everybody wanted to do. And if Mr. Hightower comes, we could discuss that then. I don't know if that's appropriate, but just offering that as an option.
Yeah. Okay. I'll just give you my instant reaction, and then we can return to it. Ideally, in Mr. Hightower's presence. I know, Ms. Nanasik, that you don't cite subpoena power for me, and I'm sure that's because it doesn't exist for me in 20.1.6, the Commission's rulemaking rules. Otherwise, you would have cited it. So I don't see how I can really order Dr. Pei-Shu to appear and give testimony, particularly because I'm guessing that the testimony would be of the expert opinion type of testimony and not sort of was the light red when the car went through it. Having said that, it sure sounded like Mr. Hightower was hoping to have Dr. Shu join him for the purposes of cross-examination. And if we do that sort of thing all the time in hearings, regardless of whether someone gives direct, if it's helpful for them to join someone who did give direct as part of a panel on cross, who has information and has been identified, then that can be very helpful. So anyway, that's my reaction to that motion. But we can loop back in the hopes that Mr. Hightower joins us before long. All right, so now let's go to Ms. Fox's challenge to the NAMOGA exhibits. Let's see, I read the motion to exclude was about 128 exhibits. And then I have the response from Mr. Maxwell. Was there a written response from NAMOGA, or will that be argued right now?
Well, Madam Hearing Officer, the motion was filed today, like at noon or something, or so I'm happy to argue today. I don't actually think it's a difficult motion, but we would, if you're at all inclined to grant it, we would request the opportunity to respond in writing.
All right. I have to tell you, it was striking that 8 exhibits identify the first NOI, and then another 128 exhibits were identified in the rebuttal. And although, I'm certainly aware that the administrative setting is more relaxed than a criminal trial court, for example, I still feel like I need to pay attention to whether you're able to lay a foundation, for example, for these. So if you would like a chance to respond in writing, that's fine.
Okay, happy to.
Now, let's see, I keep looking on the side of my computer among the participants to see if I see Mr. Hightower's name, and I don't. All right.
Resend him the link, and we're just, hopefully he'll respond and sign on.
All right. So, Mr. Wexler, would you like to loop back to the organizational questions you would like to discuss?
Yeah, yes, please.
Madam Hearing Officer, before we move to that, can I address a couple of the motions?
Yes.
Hearing Officer. First, with respect to the motion to exclude, I have already alerted Mr. Wexler to this, but I did want to alert you, Madam Hearing Officer, and the rest of the party that there are a handful of exhibits that I missed that were identified in Dr. Balch's testimony. And so I will be withdrawing my objection to those exhibits. Those are NAMOGA exhibits 76 and 93 through 97. Those are proper rebuttal, number one. And then number two, with respect to Mr. Hightower's suggestion that Dr. Hsu and Dr. Zhang testify with him in some form or fashion pursuant to the NOI that did not meet the rules requirements, we do object to that on a number of bases. In my estimation, Mr. Hightower is testifying on his own behalf, is not testifying on behalf of the consortium. And if that's the case, it is not possible for either Dr. Hsu or Dr. Zhang to present technical testimony at this point. They would have to enter appearances on their own behalf as parties. The time for that passed on April 23rd. That was the date in the public notice by which a person had to enter an appearance as a party. They cannot testify on behalf of the consortium because the consortium is not a party. They have not filed rebuttal testimony by the deadline. So they are out of time on any number of bases for giving technical testimony next week. None of the parties would have any notice of that testimony, as we do for direct and rebuttal. no opportunity, to respond, to get our experts to look at it. So they are just out of time, in my view, both Dr. Shu and Dr. Zhang for testifying. And I do agree. I do believe that neither the hearing officer nor the commission has subpoena power, and so nobody can issue an order for anybody to testify in this proceeding. So we do object to their appearances to testify and to provide technical testimony next week.
Great. Thank you for that, Ms. Fox. I continue to scan the participants, and I still don't see Mr. Hightower. All right, let's go back to Mr. Wexler.
Thank you, Madam Hearing Officer. And I want to actually address that issue first. And I'll just start by saying, that these witnesses, Mr. Hightower, Dr. Zhu, Dr. Zhang, they are part of the consortium that was developed or created to assist the department in developing information about reuse of water. So in some ways, I was surprised to see the department actually not relying on them. But the idea that we're going to try and exclude them when they want to testify is very surprising. I'd be surprised if the commission were willing to go that route, particularly given that a number of witnesses, including those from Amigos Bravos, have relied on their papers. I second on this particular issue. I would point out that in the notice of intent that was filed by Mr. Hightower, the actual testimony there is in Exhibit 1. And if you look at Exhibit 1, it meets all the requirements of the rules. It meets all the requirements of your pre-hearing conference. It indicates it's for this hearing. So this testimony was created for the purposes of this rulemaking. It's got the hearing date, the docket number. It indicates who's being represented, and then it indicates the authors. And it's not just Mr. Hightower. It's also Dr. Zhu, Dr. Zhang, and Dr. Young. It then goes through and it identifies their qualifications and then proceeds to include specific written testimony, as all four of them are the authors. So somehow the idea that they didn't sufficiently provide notice to the parties of what they were going to talk about and testify to is simply not correct. And as Your Honor has already pointed out, Mr. Hightower is not a lawyer. So, this seems more than sufficient, particularly given there's significant interest from a number of parties, including the party that Ms. Nanasi is representing, for Ms. Zhu to be there to answer her questions and all of our questions. I'm sure the commission itself would like to hear from these folks. So that's all I have to say on that subject.
If I could, before we talk about the administrative stuff, I know that you don't have subpoena power, and that's why I asked it in a different way. But one of the things that you do have the power to do, and the commission has the power to do, is issue orders. And you can issue an order if you wanted to say that Dr. Shu is a key witness here. I mean, there's it's incontrovertible. The NMED relies on her testimony. New Energy Economy relies on her testimony. Amigos Bravos and Sierra Club. Why would we want to not hear from herself? And so, to me, this goes to a key question. This is not like some report from a doctor from Tanzania or something like that. She is the associate director of the consortium. I disagree with Ms. Fox that the consortium is not an intervener. I think the consortium is an intervener, and if it's a matter of question, that should come out and be decided at hearing. And I also agree with Mr. Wexler that we were on notice, and so therefore it would be appropriate for her to testify. So.
Thank you, Ms. Nanasi. Ms. Fox, your hand is up.
Yes, thank you, Madam Hearing Officer. With respect to Dr. Pei and Dr. Zhang testifying, you know, in any kind of one of these proceedings, there may be people out there with a lot of very good specialized information. But if they don't appear, but if they want to give specialized technical information, they've got to appear on behalf of a party and file their notices of intent to testify in direct rebuttal. That has not happened. Exhibit 1 does not take the place of an NOI from any of the authors of that, of Exhibit 1. Doesn't take the place of that. I actually contemplated moving to exclude that exhibit because it looked to me like they were people who were testifying, but who were not being offered to testify, which is one reason I had the conversation that I did with Mr. Hightower. But being assured that he was representing himself and not the consortium, I thought, well, Exhibit 1 is more like an article of which he is an author and the others are an author that he can testify on about as an expert. So this is obviously getting very detailed and into the weeds, but I do have strong objections to either of them testifying at this point. It is prejudicial. Our experts haven't looked at all of their articles. We haven't prepared cross-examination for these particular people. So there is prejudice. It's inconsistent with, the rules of the game at this point. And I guess I have a question as to whether, given all the discussion, whether it makes sense. I guess, well, I won't ask. I guess I will file a response tomorrow. I didn't think that I was going to need to do that, but I think, just to clarify from our viewpoint, our position, we'll file a response.
Well, thank you. And hearing now this additional argument, it seems to me that it may ultimately just be up to the commission. I can certainly offer my recommendation as to, or my opinion as to whether Dr. Xu or Dr. Zhang should be allowed to testify without having filed an NOI on behalf of the consortium. Ultimately, though, it will be up to them to weigh the evidence and the entirety of the record and the petition without that, if that's the way that goes, or to leave the record open until they get it. I mean, I think the commission has a couple different choices here. But all right. I still don't see Mr. Hightower. Mr. Wexler, let's go back to your organizational questions.
Yeah. Some of them are very short and easy. And I'll maybe start with those. The time that the roundhouse will close, I mean, oftentimes that's an issue. Do you have a sense, Madam Hearing Officer, as to when that will be?
So we did a hearing there just about, Pam, was it a month ago? I lose track of time. Yeah, maybe 5 weeks ago at this point. In any event, we did a hearing there recently, and the instruction when we arrived was folks need to be out of the rooms by 5:30, and they did send some security folks up there to scooch us out around 5:30. But then someone asked security if in fact we could get a dispensation for even just a little more time. And we were able to stay until 6, right, Pam? Yeah. So we can ask for a special dispensation again, just to maximize each day. I think it's highly unlikely, though, that we will ever be given permission to stay past 6.
Understood. The reason I ask is I know that you had set public comment starting at 5 for an hour, which would take till 6. So that was the reason for my question.
Okay.
The second question / issue, there's it has to do with the clarification on your paragraph 6 in your pre-hearing order, which had to do with the summary for direct and for rebuttal. And as I'm understanding it, and this will lead into my concern, that is, each technical witness has 30 minutes to summarize their direct testimony and 30 minutes to summarize their rebuttal, if they have submitted both. Is that correct?
That's what was in my head.
Understood. And so, which leads to my concern, and that is, we count 17 witnesses. Now, not all are on direct and rebuttal, but I think we counted approximately, if all witnesses maximize their time for summarizing, it's 15 hours. And we have 5 days plus 2 hours each day of public comment. And so I just wanted to bring that to your attention, the attention of the parties, that it strikes me that this 1 week is likely going to fall short, but we'll see. So I'll pause there in case you have any comments.
No, you know that I will do my best to move folks along, and I know a lot of you, and I know that you won't in the hot seat longer than you need to. And you should know, if you haven't seen the commission in action before, they really do their homework. They're very good about reading the pre-filed NOIs, and so you should. I think you should work on that assumption that they will have informed themselves before coming into the room. Okay. I don't know what else to say about that. If we get to Friday and we're not done, we're all going to have to pull out our calendars and find a time to continue.
Understood. The next question I had to do with openings and then post-hearing submittals, if any. And so my question on openings is, our preference, if we choose to do an opening, is to go immediately prior to when we're presenting our witnesses in our direct case. I know that's often allowed in these rulemakings for parties, and I wanted to verify that that's something that you would allow in this proceeding.
Yeah, actually, I always invite counsel to either make an opening at the beginning or to do it right before they put on their witnesses. Either way is fine.
Thank you. And how about post hearing submittals? Do you anticipate written post hearing submittals?
So I believe that, in fact, the commission will want them. Now, is it possible that the commission will say, we're ready to make a decision right now, we don't need to put the parties to the trouble of making written submittals? I haven't seen them behave that way. It's theoretically possible. So I believe the commission will want those, and we can talk at the end of the record about how long it will take to get the various volumes of the transcript, and a sensible deadline for submitting written either proposed statement of reasons or findings, legal conclusions, closing argument, maybe even sometimes in rulemakings, parties' positions change. Kind of their last best final offer for what they think the rule should look like changes a little depending on what they've heard in the evidence. And so we ask for that too. So I would anticipate that. I strongly believe that's what the commission will want. I see your hand, Ms. Fox.
The commission's notice didn't say that it would deliberate, that it could deliberate after the hearing. So I think it's precluded from deliberating right after the hearing, because I think the rules on rules require that note that be in the notice if they're going to deliberate upon conclusion of the hearing, I believe.
I agree with you that that would be required if they were going to do it. I have not read the notice recently to see if it's in there or not. You're saying it's not. Okay. Okay. All right. Well, that's an even shorter answer then to Mr. Wexler's question.
Before I go on a look, I don't know if Ms. Nanasi had something to say on this topic before I ask my next.
Oh, I'm sorry, Ms. Nanasi, I didn't see your hand. Yes.
Thank you. Thank you both. So I have a question. Is there going to be a court reporter?
Yes.
Yes, there will
Okay,
be.
and so do we have the pleasure of getting that transcript before our briefing is due?
Yeah. Pam, do you want to address this?
I know it escapes me how many days they have to prepare that transcript, but I know that it's Albuquerque court reporters and they will do their best to expedite that for us. But given the length of the hearing, we'd have to ask them when they could produce that, by what date they could produce that.
And so my question is really, do we have a dispensation for whatever time that is 3 days a week, 10 days? Is that included in our time when we have to file briefs with the commission?
Yes. Yes, definitely. And it's always that way. We always assume that the transcript is going to be helpful in preparing your closing submissions. Yeah.
Terrific. Thank you.
My next question, I believe all of my witnesses are able to attend in person, but some of them have a couple scheduling quirks. And if the time they should testify happens to fall during one of those quirks, is there a virtual option for witnesses?
Pam, I believe the answer is yes.
Absolutely. It's a hybrid meeting, Mr. Wexler. So we have the Webex link and it will be on the calendar. It is on the calendar and they can choose to attend virtually.
Thank you. And then the last question that I had just had to do with, and I know, Madam Hearing Officer, you're going to go over order of presentation. When we're going over that, I would just ask, it would be helpful to understand if any witnesses are going to be presented as part of a panel in order for our sort of preparation purposes.
All right. You know I like panels.
I do know that.
All right. So let's talk about the order. Historically, and it does not have to be this way, historically, I arrange obviously the petitioner first, and then I move on a spectrum of more supportive to less supportive of the petition. Now, I noticed that in the NOIs, there were lots of proposed changes to the rules, and then, of course, more strongly stated objections around adopting a rule at this point at all, before some of the details of such a program would be worked out. So, enemy D will be first for sure. Does it make sense to put who next?
The consortium, please.
The consortium? So, do you mean Mr. Hightower from the consortium? Okay.
Yes, and if the commission allows Dr. Xu, then her next.
Right. Okay. So we'll see about that. And then who after Mr. Hightower? Ms. Fox?
Amigos Bravos and Sierra Club do support the general prohibition, and so it might be that, whereas Mr. Hightower does not, so it might make sense for us to go next. And in that regard, Dr. Lewis will be coming from Denver, but he will be coming in person. And so I would like to be able to identify at least a day, if not a time, but particularly a day that he could testify, if that would be okay, since he is traveling from Denver. He can be available any days of the week. If we're thinking about NMED going first on Monday, I'm not sure how long the agenda for the WQCC is for that morning, or when we will begin, but maybe we would go, we could schedule Dr. Lewis for Tuesday morning, or Tuesday.
All right. Yeah, there is one reasonably substantial matter on the agenda before we get to this hearing. Let's see, it's the one where Mr. Nasco is asking for a stay of a commission decision until the district court's decision upholding them goes through the Court of Appeals, right, Pam? I think
Carly
that's
matter, yes.
Yeah, that's the Carly matter. So anyway, we'll definitely be hearing arguments both ways, and the commission will deliberate on that. That won't be a 10-minute thing. I don't think there are any other substantial matters, though, right?
No, nothing
Okay.
other than minutes and agenda.
All right. So thank you, Ms. Fox, for being clear about Mr. Lewis's availability. So we'll plan for that. And by the way, if someone else has a particular witness constraint, we always work with those.
And then,
Yeah.
Madam Hearing Officer, if our witnesses, are ready to, if they come up we're lucky enough that they come up on Monday, Mr. DeSalen could testify, on Monday before Mr. Lewis, but we'll plan on Mr. Lewis testifying Tuesday at some point. I appreciate the accommodation from you and the other parties.
Sure. All right. Then we have, let's see, Waldorf Guardians and New Energy Economy. Who would like to go after Amigos Bravos?
Well, I wanted to first raise something with you. If it's possible, Dr. Van Gogh would like to go on Monday, May 13th. He has travel plans, and that would be the most convenient, which I know would be out of order. So I'm wondering I don't know how long the cross-examination would be of him, but
I know he's he's your rebuttal witness.
I know.
No.
He's one of the rebuttal witnesses.
Sorry? Yeah, one of the rebuttal witnesses, other than the two original. Yeah, Monday is going to be tricky then that way.
Yeah.
Because there are 5 witnesses for the department. And again, we're not starting right away with the first. And then we're doing public comment at 5, right?
I think you had said noon on the 13th as well as at 5.
Okay, hold on. Sorry, I have to double check.
Yeah, it's paragraph
Madam
7.
Hearing Officer.
Paragraph 7. Okay, thank you. So yeah, at 12 and at 5. Okay, on May 13th and 9 and 1 on May 14th. Okay. Yeah, not to exceed an hour. So I don't promise a whole hour if that's not something the security guards will let us do. I don't want to be hauled bodily out of there. Okay. Thank you. So Monday is very tricky, Ms. Nanasi. If if uh, if we had to push them to Tuesday, would that be okay?
I will text him right now. I do have another request that Mr. Gaum would like to be done by close of business on May 16th. I'm just letting you know those are my two requests. So it wouldn't be a panel because unless Mr. Noble and Mr. Gaum were called on the 15th or 14th, that would be either or the 16th, but together, but just to be done at 5 o'clock on 5/16.
So I don't see a problem with that. And I would say then that we should really have you following Amigos Bravos and Sierra Club, just to make sure that Mr. Baum is done by the 16th.
In terms of order of witnesses or in terms of cross-examination?
Well, I think so you have Mr. Baum and Mr. Noble, and then you have them also on rebuttal along with Dr. Vengosh. So again, we're selecting the order that the parties are going to go in. They'll do their presentations. I guess I haven't mentioned yet. I know rebuttal tends to sort of meld into, people's direct presentations, which is more efficient than pretending that they don't already know what they're going to say on rebuttal, if you know what I mean. So I think if we put you after Amigos Bravos and Sierra Club, your presentation can be done by 5/16. I really believe that. So then Wildor's Guardians after New Energy Economy. Yes?
Madam Hearing Examiner, I can make Ms. Troutman's available at any time, so that works for us.
Okay. All right. So now what makes sense? I was going to put Namoga last. Let me just say that right now. No offense, Mr. Wexler.
None taken.
All righty. And I was going to put Mr. Maxwell right before them. So then we just have Select Water Solutions and Center for Biological Diversity, and then the three individuals. Any preference there?
Madam Hearing Officer, the Center for Biological Diversity, we don't have a strong preference, and we're not presenting any witnesses, so where we go in cross order is not a big deal. And it's my understanding that Mr. So, Sage, and Atencio won't be doing cross.
Okay. Well, thank you for mentioning that. All right. And then Ms. McCaleb or Ms. Taylor, do you want to follow the Center for Biological Diversity?
Madam Hearing Officer, that would be just fine.
Okay, thank you. Ms. Fox, I see your hand.
Yes, is the idea that we'll do direct and rebuttal and serve rebuttal together in one fell swoop, or that we'll do direct and then come back round for rebuttal, and I asked because of Dr. Lewis's schedule. From our viewpoint, it'd be preferable for him to give it all in one fell swoop. If that's not possible, he can appear virtually for his rebuttal and serve rebuttal, but just want to be clear on how that's going to work.
Let me ask you, Ms. Fox, is there any reason not to let the parties make that choice?
I would have no objection to that.
If I could be heard on that, I agree with Ms. Fox that the most efficient way to do it is simply have everybody put on both direct and rebuttal at the time they come on. That way we're not having to bring people back, stuff like that. I mean, that's even in the much more stringent, in court, whether state or federal court, that's typically the way it's done. I mean, if a judge is allowing rebuttal expert reports, when they go on, there's still that expert witness still has to produce all opinions that they're going to testify to, whether they're in their original report or their rebuttal report. And it just makes for a much more orderly.
Okay, it makes more sense to me as well. I think it is more efficient. All right, so let's plan it that way. Let's see. So we have the order.
Can I just ask for verification on the order? Because I wasn't entirely sure. I wrote down the department and then the consortium, but I wasn't clear if the consortium was next, and then Amigos Bravos and the Sierra Club, and then NEE, and then Wild Earth Guardians, and then the Center for Biological Diversity, and then Select, and then Maxwell, and then NMOGA.
Yes.
Thank you.
And there's the three individual parties that are after or before CBD.
So Mr. Cox said that I think Mr. Cox just said that they're not planning to conduct cross-exam. Did I get that correctly?
That's correct, Madam Hearing Officer. That's what they've explained to me. They'll probably be presenting some things during the public comment section.
Oh, they don't want to present. Okay, I was talking about their testimony, not their cross-examination.
But they're not going to cross-exam. That's what he.
Right. No, but I was talking about them giving their own testimony.
They're also not giving technical testimony.
Right. So I'm going to call on them whenever they ask me to call on them during public comment. Great. All right. Is there anything else we can talk about? I am checking participants again and still do not see Mr. Hightower. Is there anything else we can talk about while we're all on the platform together? I suspect all of you are familiar with what it means to be at the Roundhouse. Parking is available, in that garage. It's available in the PERA lot. You can't have anything other than maybe a discreet bottle of water in the room. No other drinks or food or anything like that. We will take breaks to allow people to find lunch. We will not take a dinner break because we'll have to be out, as I said. I strongly suspect we're going to have to be out of the building entirely by 6 p.m. Let's see, Ms. Fox, I see your hand. I'm not hearing you, Ms. Fox.
So, sorry about that. Just a few logistical things. For documents that we may want to use for cross-examination, should we provide paper copies? Should we provide them virtually to the commission? Both? How would you like that done?
I think it will probably be best to provide a paper copy to the witness, right? So that they are looking at the same thing you're looking at. Let me think here. What's the best way, Pam, what's the best way to share things with the commission in real time?
I know they all have either a tablet or a laptop with them. They refer to the docketed matters page, or they've downloaded things that they want to look at themselves. So I would say electronic copies, a thumb drive.
We probably wouldn't want to provide 15 thumb drives.
Right. Eh,
Maybe paper.
Gosh.
Maybe just do it the old-fashioned way. I don't know.
All right. I'm not sure how to do that in real time in a remote location is my issue.
Yeah.
Well, it does.
Let's see. I see Ms. McCaleb's hand.
Oh, and I've got 2 more questions.
Oh, sorry.
So Ms. McCabe is welcome to go before me. Okay. One is if anybody is planning on presenting demonstrative evidence, like a PowerPoint that won't be entered evidence but is used, I would usually there's a requirement that that be submitted to the parties, like a day before or something, and that obviously the demonstrative stick to the evidence. And I was wondering if we should have, that kind of a guideline for demonstratives. And then also, this is getting pretty in the weeds, but it's key. For counsel's table, generally speaking, there's not as many lawyers at the WQC proceedings as there are now. And we're usually able to sit at a table where we can put our books, which is very, makes it a lot easier to, conduct yourself in the proceeding. And so I wanted to make sure there was going to be counsel table there for at least one lawyer for each party to be able to sit and have a table to put the materials on. So those 2 issues.
Yeah. I think the table thing is going to be a hard ask. We have rounded up a couple of tables from legislator offices in the past without too much issue. But we've got 8 parties, and I don't think we're going to have 8 tables, for example, for that. But
2 tables.
in fact,
2 tables with 4 people. Anyway, I'm used to having it there, so I put that request out, understanding the logistical
we'll try to
difficulties.
round up some tables. We'll have to work with what we get. Okay, but I meant to ask, and thank you for that. I'm juggling too much paper over here. I meant to ask whether folks were hoping to show PowerPoints and to put a Friday afternoon deadline on that for sharing with other folks if you do, because you described our usual practice accurately.
So we are planning on doing PowerPoints, although honestly, I'd be surprised if our witnesses go on next week. But you did include a paragraph 12, a deadline of no later than 12 p.m. on Friday for those demonstrative exhibits. You did also mention a Dropbox link, which struck me that Ms. Fox's point about additional cross-examination exhibits or whatever, like that would be a very easy way to deal with the electronic submission of those kinds of exhibits.
Okay.
Yeah, that is what I was going to ask as well. So I think that what makes sense is if you want us to have a paper exhibit for a witness who's live with us, that's good. But also if you can give us a Dropbox link, and then each party, puts all the exhibits in that they want to use on cross-examination for the witnesses. And then do we list the exhibits, have an exhibit list that we put together of all the exhibits that we have? Or you don't need that?
Well, oh, you mean the demonstrative exhibit?
Well, that's what I was going to ask you. I mean, there are questions that I would like to ask some of the witnesses, for instance, and I have not tendered them in the direct or rebuttal, but I would like to ask questions of those witnesses. And what the practice that I'm used to, at least of the PRC, is you can do that via Dropbox. You put an entire list of exhibits plus the exhibit itself, and then you can use that in cross-examination. And then if you want to, you can ask for that exhibit to be admitted. Sometimes you don't need it to be admitted, but sometimes you want it to be admitted into evidence, in addition to just it being demonstrative.
Mhm. Okay, no, I understand. So I will send a Dropbox link, and what's lovely about a Dropbox folder, even though it's a little old-fashioned, is that, you can put a PowerPoint as big as you want in the thing, and anyone with the link can access that. So, Ms. Nanasi, I think your suggestion is a good one, to include cross-examination exhibits in there and a list of them for the commission's ease of reference. And thank you, Mr. Wexler, for pointing out paragraph 12, where I'd already talked about demonstrative exhibits and the deadline on Friday for that. Let's see, Ms. McCaleb.
Thank you. I just realized that you had addressed this in paragraph 14. I was going to ask whether cross-exam would be in the order of presentation or reverse order. And it looks like it will be in reverse order, meaning Namoga would ask cross-examination questions first. Is that correct?
Yeah, and you can imagine why that would be so. It allows the party who presented it and their closest allies the opportunity to rehabilitate as necessary. All right.
Thank you.
Thank you. Ms. Fox, did you have something else? No. Okay. Ms. McCaleb, do you still have something? Nope. Okay. Ms.
No, ma'am, I'm
Nanasi?
sorry.
Okay.
No. I went. Thank you. So, yeah.
Okay. And Mr. Wexler, anything else?
Well, I do have one question now that you mention it, and that is for panels, since I suspect that people are trying to figure out whether they're going to do panels or not. Will we be allowed to have more than one witness, attorney question the panel? In other words, it may be that, let's take the department who's going first. They have 5 witnesses, but we're splitting up internally questioning as between 2 attorneys. I mean, we'd like to be able to have those 2 attorneys address the panel.
Yeah, no, that's fine. I just wouldn't want counsel double teaming a single witness. That's all.
Madam Hearing
Let's
Examiner?
see. Yes.
I had another question. In terms of erratas for the admission, and so I just wanted to know your practice. So you put on a witness, and other than having them identify themselves and being sworn in, is the way it goes is, what about erratas? Like, so there's typos and things like that. At the PRC, they don't care about typos anymore. Make them, and then you don't list them. You just make them, and then you give the parties a red line version, and then you give a clean version. Or sometimes they just say erratas, typos don't matter. So what's your position on that? And then the other question. Oh, and then I had something else about. And then do you go through like that part of the admission of their direct and rebuttal, for instance, and then they give their 15 or 20 or 40-minute summary?
Yeah, so typically it's first the witness goes under oath. Then they are asked, did you prepare written testimony? Do you have any changes to that testimony? Do you adopt it under oath? Please give a summary. You've described basically how it goes. And so if the changes are worth mentioning, then they're mentioned, right? And if they're not worth mentioning, formatting infelicities or something, then they're not mentioned.
Okay. All right. Good to know about that.
Let's see. Anything else?
I did have an additional question, even though it wasn't my motion, and it was Sierra Clubs and Amigos Bravos. How long does Mr. Wexler have to respond? Because that's going to impact our preparation. Because if you rule that it's excluded, then we have a lot, or just some less work to do. So I'm just wondering, does he get? How long does he get, and when is that determination going to be made?
All right. Mr. Wexler, can we have your response by Friday?
Let's see. I have to be at a deposition, I have to help prepare for that deposition tomorrow afternoon, and I'm at the deposition all day Friday. So we would ask till Monday.
Okay. Monday morning, please.
Sure.
All right. Anything else at all we can talk about while we're all on the platform together? No? Okay, well, it's been a pleasure, and I look forward to next week. And I will get out a Dropbox link. And if you have any trouble at all with the Dropbox link, please let me or Pam know. Thanks so much.
Thank you.
Thank you.
Thank you.
Bye.
Thank you.